Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's presidential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. Paralegals are often the backbone of immigration law, and in 2025, their role is evolving fast. My friends at e-immigration asked the experts what sets great paralegals apart in 2025. From ethics to tech savviness, these are the top 5 skills that help paralegals go from good to great. Head to get.eimmigration.com/resources to read more, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, friends, families, loved ones, and Ira. As you all know, Supreme Court season ended as it does every summer. Trying to create a bit of a podcast tradition here. That means, just like last year, we're going to do a Supreme Court Roundup with none other than Ira Kurzban. Ira and I sat down at the end of July and talked about a lot of Supreme Court cases. Some of which you know, some of which I've done, but many of which I have not. Talked about some Supreme Court decisions as being very generous. Most of the talking was done by Ira, which I know is what you guys want to hear anyway. You all know who he is. So without further ado, here is our Supreme Court Roundup 2025. Ira Kurzban on the Immigration Review Podcast. Ira Kurzban. Is it pronounced Ira? It's IRA?
Yeah, actually, I learned today in looking at my father's certificate in coming into the United States in the 1930s that my name was spelled differently, as I always suspected, which is there is no K and Z normally in Romanian. So my father put on the original document Cursban, and that was, in fact, my real name. And then they Germanized it when we came in.
Kurzban. So there should be Kurzban. Is that like a curse on you? A curse on the government. But you're new to immigration, right? How you started during this last administration? How have you found it being new to immigration? And this is all wild, right? I mean, this is
an exciting field. Who would have ever imagined that they would have, gulags in the Everglades and taking people to modern day concentration camps in El Salvador and things like that, taking people to South Sudan, even though the statute says something very different. Who could have imagined?
You sound like you're actually not new to immigration. I've never heard of you, but I'm not really in the know. But thank you. Your people reached out to me, so I thought I'd indulge them on this up-and-coming immigration attorney who wanted to talk about Supreme Court cases.
Okay, so let's talk.
It's a pleasure to have you back, Ira. We do this every year. We've got a lot of things to talk about. You sent me your list of things you want to talk about, and it includes shadow docket cases and a lot of non-immigration that also affects what we do. I'm excited to talk about all of it. So please, where would you like to begin?
Let me run through some of the ones that I think you've already done, but people should know if they didn't hear your brilliant broadcasts, which are, first of all, Buafa versus Mayorkas, 145 Supreme Court 24. That was a December 10th, 2024 case. It was a case that answered the question whether or not the language of 8 USC 1155 that the DHS secretary, quote, may at any time revoke approval of a visa petition means that there is no judicial review because it's precluded under 242A2B II. The court determined that in fact was the case, that words like may clearly connote discretion, which I don't actually believe is always true. But this was, I think, kind of a typical, very narrow construction of statutes, so that it's going to be very difficult in the future to challenge any revocation. Two things to keep in mind. One is if you have a procedural challenge, you may still be able to get around it. And the second, of course, is you always still have an administrative appeal to the AAO or the BIA.
Before you can, just because, of course, I remember it, it sets up this pretty absurd situation where you, of course, can challenge the denial of an I-130 or an I-140 petition, but you can't challenge on the merits, at least, the revocation of it. So if USCIS wanted to be really cynical, they could approve petitions and then revoke it and insulate themselves from federal court review, which I think is one of the arguments that was made to the Supreme Court, and Supreme Court didn't seem to care about it very much.
Yeah, I think that's right. I think the court just saw it as a policy argument. And once again, looking at the statutes, the statutory language, and narrowly construing the statutory language as they have in other cases, such as Patel, as we know, they determined that there is no review. Of course, that leaves open the possibility of just filing a new petition, having them deny the new petition, and then doing it and, bringing a lawsuit on that. But the court just wasn't moved by the argument that it made no logical sense to interpret the statute the way that they did. The next case was Monsalvo v. Bondi, and that was the case, when does the 60 days for voluntary departure end when it falls on a weekend or a holiday? The interesting thing in this case was, of course, they said it can go over to the next day, and therefore they interpreted consistent with other provisions that said, if something falls on a Saturday or Sunday, it can be it will go over to the Monday. And this was a case where the person waited till the Monday, filed on the 60-day VD, and the lower courts were saying, and the BIA was saying, too late because it wasn't within the 60-day period. The court said, no, it does fall under the next day. What was really interesting about this case is, when does the BIA enter a final order for purposes of the 30-day period to initiate federal review? And the court in Monsalvo determined that despite not filing a petition for review within 30 days of the final order of removal, the court had jurisdiction to hear the claim regarding the 60-day time period, because Monsalvo Velasquez, in their words, quote, had no reason, end quote, to seek judicial review immediately, as the issue did not arise until the BIA, in a motion for reconsideration, denied his reading of the 60 days voluntary departure period. Now, if that sounds kind of interesting and familiar, it's because of the next case where they said just the opposite.
Right.
Riley v. Bondi, where they said apparently it does matter, and you have to file within the 30-day period, although it's not jurisdictional, in order to preserve the what amounts to the CAT claim that may be decided 6 months, a year, or even a year and a half later. So what do you have to do now? You now have to file a kind of preventive preemption order appeal, and then wait on the underlying order, right, of removal, and then wait till you get the decision on the CAT relief or on the withholding relief file an appeal on that and then move to join them under 242B9. Remember, Riley was an INA 238B proceeding, which is an administrative removal order, much like 241 removal orders, where they're administrative, 241A5 removal orders for reentry after deportation, but you still have the right to seek withholding and so
Right.
forth. And so the question here is, why would you have to file an appeal of the underlying deportation order where you may not have an issue? The court nevertheless determined that you had to do that. So, the issue then in Riley, of course, ultimately turns on what is the need to file two appeals when the first appeal is really just simply a preventive appeal?
Can I answer your rhetorical question?
Sure.
I think the answer is Justice Alito.
Oh, yeah. Well, I think they were struggling with Nasrallah and had to treat Nasrallah as an independent issue. Yeah. But I think the dissent, I think, really nailed it in a number of respects. Justice Sotomayor writing in dissent on this, 4 members, Kagan, Jackson, and Gorsuch. And I think her view was it just made no sense to require a second notice of appeal when the real issue was always and would always be the withholding of removal. The majority gives no argument, she says, for reaching the opposite conclusion. It stands alone, moreover, in asserting that a straightforward reading of the statutory text resolves this case. Even the courts of appeals have attempted to defend the majority's position, admit that, quote, the definition of finality in 1101A47B does not squarely apply to expedited removal orders and others. And then she says, perhaps the idea is that non-citizens may seek judicial review of their CAT claims only if, by luck or happenstance, they also have a challenge to the underlying order of removal. The majority's finality rule, however, prevents CAT appeals even under those circumstances. And she goes on to talk about some of these issues and why it makes little sense to require people to do both. The only bright spot, of course, in the decision is that the court has said that the 30-day petition for review period is not jurisdictional, but is a claims processing rule. So now you have the possibility, of course, always in the future of making an argument if you miss the 30 days that there was some good reason to have done so. Oil
is always going to assert the claims processing rule now. I mean, yes, we have people who missed the deadline will have an argument, but oil will always assert the rule. Riley seems dangerous, and I've talked a lot about it, and with a lot of the people litigating it, like Naila Trina Realmuto is litigating a lot of these issues. First, Riley's in the Faro context, as you mentioned, and people are taking the position, and there's case law for it, that withholding only after reinstatement is different, and that it is the denial of withholding of removal after reinstatement that triggers the 30 days. But in the Faro context, it is the final administrative order from ICE. And to me, I understand the case law is there. I'm not so confident it will hold after Riley. If the Riley court is tethering petition for review to the final removal order, even in reinstatement cases, that would be the old order being reinstated. But there does seem to be that distinction, which is helpful for non-citizens at present.
And I think the other issue raised by it, Kevin, is the question of, does it apply to expedited removal orders? I don't think I think the assumption was that it did not, but I'm not sure that's so. I mean, in other words, you have an expedited removal order, which you really can't appeal in some sense, right?
Mm-hmm.
And then months later, you have a withholding of removal or an asylum issue. Are they saying now that withholding an asylum cannot be appealed? I don't think that can be the case. So what is it? I think for your listeners, I think one of the issues that's raised is what is it that one would do in that situation? In other words, you have an expedited order of removal, you ask for asylum or withholding, you get a hearing on that. It's now 6 months later while you're sitting in detention, of course. Did you have to appeal the expedited removal order, and how would you have appealed it? There is really no appeal per se. You could file a habeas, I suppose, right? So
even in the federal context, as you mentioned, it sets up this situation where attorneys might have to file frivolous petitions for review. Mr. Riley might not have had an argument that he wasn't an aggravated felon, and yet still he must petition for review. That's a very dangerous position to be in as an attorney.
Well, I think you have to say it's a protective appeal. You have to acknowledge that given the Supreme Court's decision in Riley, I'm just filing a protective appeal so that I can file another appeal later on.
I truly try not to be cynical. I do with cases. It's the Supreme Court's making it difficult, but I can't shake the feeling. Justice Alito, Nasrallah, I want to say he's the only dissenter, or if not, like he's in the dissent in Nasrallah and in the one after it. I feel like this is Justice Alito saying, you know what? You want this rule? I'm giving you this rule. I can't shake that that's really what's happening.
Well, what's even worse, of course, is what happens when the government comes in and says there's no basis for this appeal, right?
They dismiss it before CAT is even denied.
Right.
Yeah,
exactly.
I think he just
right, and or worse, that it's speculative. How do we know the CAT's going to be denied? So why would the court entertain a protective appeal?
Right.
Okay, and then comes the universal injunction case, which of course is one of my favorite cases to talk about because the Solicitor General Sauer did something that I must say is brilliant. Sometimes I think he must either intuit or understand completely the justices, or maybe the Christian nationalists who have invaded the Supreme Court come out publicly.
Oh my goodness!
Are passing information on. Who knows? But nevertheless, this is it was a brilliant move on the solicitor's part to separate the clear issue of birthright citizenship from something he knew or must have known, that a universal nationwide injunction would not be looked on particularly favorably by this Supreme Court. Of course, the interesting thing of this is when the shoe was on the other foot, when Biden was getting pummeled by these kinds of injunctive orders from the Western District of Louisiana or the Northern District of Texas or the Southern District of Texas, we didn't hear much grumbling about the universal injunction.
To the opposite, Stephen Miller's Twitter feed was all over his love of universal. He loved them. He loved them with his whatever that group was in D.C. he was with. So if your point is hypocrisy, please speak. You're talking to someone who would have been directly affected by the student loan case, which, by the way, the state of Missouri had no standing, but I digress.
Right. Well, the question was, of course, may a court grant a universal and nationwide injunctive relief, or should such relief without a full explanation be limited solely to the circuit or individual where the issue has been litigated? And the Supreme Court, as you know, after the issuance of numerous universal nationwide injunctions by individual district judges, we think ended the practice. It's actually not completely clear, because the court never says that they're absolutely prohibited. Justice Barrett's opinion really says, just looking at whether under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions, and she says under that act they did not. The court was careful to avoid ruling, and this is the thing that I find most interesting in the opinion, often buried in footnote 10 and in Justice Kavanaugh's concurring opinion. They don't touch 706 of the APA, 706-2. In other words, we're striking down universal injunctions, but for the APA, saying holding unlawful and setting aside agency action, you can continue to do that. Now, that obviously works both ways, right? I mean, we've used that in the Haitian case very, very recently to say, in effect, that Secretary Noem didn't have the authority to cut 6 months off of Haitian TPS. And we argued there that 706 authorized the court to hold unlawful and set aside that agency action. But I think, and maybe I'm even more cynical than you are about this, I think that's really designed to protect the anti-environmentalists, the Koch families, the people who don't like the FTC, the FDA, the people who want to go after the agencies. They didn't want to prevent them from striking down regulation after regulation. And they've often been, the majority in this court has often been on the side of those people and those corporations. And so they've left open the ability, in effect, to get what would be a nationwide ruling, but it's in the context of the APA.
Of course, and I think that's completely right, but it wouldn't be the first time that immigration makes strange bedfellows on the law. We take what we can get. If they're going to leave us the APA, we'll run with it, as we did in the Hecka case with Brian Cave, Just Futures, Raymond Audain, and as others are doing with all of their lawsuits. We'll take it. And
the majesty of the law, right? What I like, though, is what Justice Sotomayor said in dissent. The government does not ask for complete stays of the injunction as it ordinarily does before the court. Why, she says? The answer is obvious. To grant such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text history, this court's precedent, federal law, and the executive branch practice, talking about, of course, birthright citizenship. So that was the brilliant move on behalf of Mr. Sauer, trying to separate out both. But here's what they say, because here is the real problem. If you don't have a universal injunction on a serious constitutional claim, and keep in mind they haven't completely ruled it out, and they have said, of course, that you can have a class action lawsuit, although that's going to be an interesting separate fight down the road at some point. But the real problem is, without injunctions that are broad, whether they're statewide or circuit-wide and so forth, if you're left to the individuals to fight it, what would that mean in terms of birthright citizenship? That somebody in North Carolina and somebody in a small town in Georgia and somebody in Eastern California would have to bring their own lawsuit, and whether or not they'd have the ability, the financial ability to do that. And Justice Sotomayor, of course, points that out. She says, no right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. The majority holds that absent cumbersome class action litigations, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief. So this is the problem that we're facing, right? That Trump tomorrow can decide, or the Republicans tomorrow can decide to not issue birth certificates. Let's say a child in a hospital in North Carolina or in Mississippi or in Georgia or in Florida, and those people, those individual families would have to file lawsuits on this. And that's the trouble with doing away completely with universal injunctions. And by the way, when Sauer was asked that question in the oral argument, he really had no answer to it. Like, how are they going to possibly administer this? So there'll be effects of this in the long run.
It's wild. It's terrifying. The court has ruled. What scares me is they do know what they're doing. So I'm not sure what the grand plan is. As I think we talked about this last year during this interview, these aren't the actions of a court and an executive that thinks they're going to lose power. These are the actions of people who think they're going to have power forever, and they want to take it to the maximal extent. And that is just a terrifying thing. And I guess to piggyback terrifying onto terrifying, I am curious what you think, Ira. How does it ultimately play out? How do you see birthright citizenship going? Everyone's real bullish that, of course, the Supreme Court's going to uphold that because of an 1895 decision about Chinese rail workers, if I'm not mistaken. But what do you think if you're really reading the court?
Well, I think it's a very close question. I think it's a closer question.
It's terrifying.
Not legally.
Right.
I think politically, it's a closer question for this court than people think. I think it's possible, as one court already has, is to seize on a misreading of subject to the jurisdiction and what that really means. But I think the court, in all fairness, given the history of birthright citizenship, and as Justice Sotomayor so eloquently discusses in her dissent, we've had it from the founding. That is, it is true that there's a 14th Amendment issue, but we've always had birthright citizenship. And it was only because of the Supreme Court's decision in determining that African Americans were property and not people, that the 14th Amendment was necessary. So that even in the 14th Amendment, it's clear that it went back to all the precedents before that in the founding and basically said there's a very narrow exception for Native American tribes because they're independent nations and therefore not subject to the jurisdiction, and for diplomats and the children of diplomats. But other than that, there's never been a question that birthright citizenship birthright citizenship always applies to everyone else. So I think the court would have to, there may be dissents, Thomas and Alito, but it would be shocking, really, if they looked at it from a legal point of view and not a political point of view to do this. And think about the chaos it would create. Think about, what would happen if we really had this birthright citizenship and what each state would then do. What happens if they say, yes, birthright city, you have to be subject to the jurisdiction. Well, in the state of New York subjects people to the jurisdiction, and what the consequences would be thereafter. So I think if it goes to the court, they're likely to do the right thing and make it clear that Wong Kim Ark and all the practices we've had since the founding of the Republic support the idea of birthright citizenship. Okay, let me move on because we've got a bunch of cases here. Lackey v. Stinney, 145 Supreme Court 659, February 25th, 2025. This is the case on whether preliminary injunctions would allow for attorney's fees under Section 1988B of the Civil Rights Act. And the court says because preliminary injunctions are not do not conclusively resolve the rights of parties on the merits. The court held that they, quote, do not confer prevailing party status. I think this case will have tremendous implications for the use of the Civil Rights Act in 1988. I think it's a mistake. And I think we're going to feel it not only in the civil rights context, but it's soon going to be used under the Equal Access to Justice Act cases as well, just as Buchanan was previously, which was not a EAJA case and then was used as the basis to say EAJA fees were not permissible under those circumstances. I think we're going to see the same here when preliminary injunctions are won, where the government is going to say you're not entitled to fees.
Because so often the fight in these cases is at the preliminary stage, and lots of things happen afterwards. And if you can't count on possibly getting fees there, it becomes a rich person's game where unless you can fund the whole thing yourself, you're not doing it for fees. It's in line with making federal court practice prohibitively expensive to the vast majority of Americans and even law firms, and only making it a place where rich people can play, even in the civil rights arena, right?
I think that's right. I think that it undermines dramatically the Civil Rights Act, which was to appoint attorney generals. Same thing with EJA, to allow people who didn't have the resources and were going up against the government to be private attorney generals and be able to collect fees. So I think this is just another way of undermining the civil rights laws and the equal access to justice. Martin versus the United States, 225 Westlaw 1657418, June 12th. Homeowners brought an action because this was the wrong house raid by the FBI. You may recently note that this happened in Missouri, I believe, where ICE went in, raided a family, threw the mother and 3 children out in the rain in their night clothes, basically took everything in the house that there was to take, and then the day later admitted that they were in the wrong house.
Oh, my goodness.
So the question is, does this fall under 1346A, which waives sovereign immunity for certain torts committed by federal employees? This was a case involving negligence, emotional distress, trespass, false arrest, and assault. The lower courts granted summary judgment. The 11th Circuit found that the wrong house was shielded by the discretionary function exception under the FTCA because it was negligent, not intentional. But what the court did was very interesting. They said the law enforcement proviso, 2680H, prohibiting the assertion of sovereign immunity, it overrides the intentional tort exceptions. That is, there's a whole list of intentional torts like trespass, false arrest, assault, battery, etc. Those are things for which somebody can bring a federal tort claims action against the government. But they did say here that that doesn't mean that the government can't rely on the discretionary function or other exceptions under 2680, so that one might be able to say, despite the fact that it was an assault, battery, false imprisonment, false arrest, abusive process, or malicious prosecution, which are all the intentional torts for which you can sue the government. And keep that in mind, Kevin, because we're going to see more and more and more actions against the ICE when they bring on 10,000 people, probably without any regard for their backgrounds. Who knows, since they're disregarding civil service, who knows who they'll bring to enforce the Immigration and Nationality Act in the way they have. That is, using these ICE people in some sense as thugs. I mean, that is, they're They're not dressed in uniform. They have masks on. People don't know who they are. They're throwing people in vans, etc. And they've already arrested hundreds of American citizens and lawful permanent residents. So we're going to see more federal tort claims cases. The government may raise, and this case allows them the discretionary function, but I don't think that's going to fly when an ICE person, one of these 10,000, starts beating an American citizen over the head or starts doing what they're doing in Los Angeles, which is, as a federal judge noted already, basically racially profiling. If you're Hispanic, if you're Black, there's a much higher probability that they're going to go in and arrest you without regard to whether or not you're an American citizen or lawfully in the United States. So Martin versus the United States is an interesting case, because of the fact that it highlights once again the use and importance of the Federal Tort Claims Act. But on the other hand, it does give the government an out if they can establish that it's discretionary. The interesting part, again, was in Sotomayor's concurrence in the case, where she suggests a very narrow interpretation of the discretionary function exception and finds that it may be inapplicable to a wrong house raid. And that's worth a read for those of you who are going to be doing these cases. And I hope all immigration lawyers will start to learn to do Federal Tort Claims Act cases. And we're going to be setting up a project to see that happens.
Yes, sir.
Okay, two cases on the next term. The Geo Group versus Menacol. Claims were filed by immigration detainees against the GEO for violating the TVPA, Trafficking Victims Protection Act, and unjust enrichment.
Is the case out of Washington?
Yes, this is the $1 a day given to, quote, incarcerated people, even though they're awaiting a civil removal case. How are they incarcerated? The government says they're not prisoners.
Well, how are they incarcerated? And isn't that unauthorized work?
Well, it certainly is if you don't want to do it, and you're trafficking people and telling them you have to do it, or you wind up in solitary confinement, or you wind up you wind up being punished. That sounds an awful lot like these are incarcerated people, and we're only going to pay you $1 a day. Geo, which will soon become a gazillion-dollar company as a result of the $140 billion being given to open up new detention centers. Geo lost on the merits of the legal argument that enjoyed derivative sovereign immunity. The interesting thing about this case is, again, it's a procedural case. In a way, it's like the universal injunction case. They're not fighting on the merits. They're fighting on whether or not they can appeal, whether an order denying a government contractor's claim of derivative sovereign immunity is immediately appealable. That's the issue in the Geo case, not whether or not they have derivative sovereign immunity, but whether or not they can appeal it. And
isn't it so clear in the CASA case, in so many of these cases, that the government's not interested in talking about the merits? They don't want to bring the merits of these things to the American people. They want to get it on legalese, technicalities that we learned in Civ Pro and federal courts classes and all these things. They don't even make good headlines. It's just so telling, it seems, and sad. The American people can't make decisions on these important issues if they can't even really understand what's going on, and they think it's all above them. People can understand facts. They can't understand jurisdiction.
And what's worse is, of course, like, let's take the universal injunction case. The government walks out like they have this major win, as if they won on birthright citizenship, which clearly was not the case in front of the court, and hopefully will be, and will be sustained, allowing birthright citizenship. But and Trump's order will be stricken. But you're right. From a political point of view, it looks like a win for Trump when it's not a win on the underlying merits of the issues. The second case that the court granted cert on is a little frightening.
We're not at the frightening part yet? This is only where the frightening part begins? I thought we've been in the frightening part for the last half hour.
No, this is where the real frightening part.
Oh, my goodness.
Okay. Urias or Orleana versus Garland, 121, Fed 4th, 327, 335-36. Cert was granted on this. The First Circuit has always been very tough on what constitutes past persecution. If you look at the cases, there's some really horrible cases out of the First Circuit. This one was death threats against somebody, and unless they're so menacing as to cause significant actual suffering or harm, the court didn't believe that that would necessarily be a form of persecution. And the court has granted cert to determine the kind and degree of harm constituting persecution under 8 U.S.C. 1101A42, and whether to defer to the BIA's judgment and fact-finding on persecution post-Loper-Bright. So this is one of those that I was talking about when all of my colleagues were saying how wonderful it is we now have Loper-Bright and everything. And I kept saying in the background, the government will find a way to make sure that the BIA's decisions will be followed one way or another, notwithstanding Loper-Bright. And this seems like they're going in that direction because the solicitor also agreed on cert in this case on the grounds that, we really should follow the board's decisions under the substantial evidence test and not go out on our own on Loper-Bright, for example, and determine what persecution may be. Okay, just a couple of quick other cases in the court, and then we'll get to my favorite issue, of course.
Before we get to those, just for everyone, I did remember the Urias case. It's episode 238 of the podcast, if anyone's interested on the background from the First Circuit. For a refresher, I didn't know it was going to the Supreme Court. We'll be doing it again, I suppose, next term. But it's
I'm sure you did it very thoroughly.
I don't know. There are so many at this point. I remember it vaguely. I remember the name. The death threats as persecution thing, there's absolutely, the circuits are all over. The panels between the circuits are all over, too, on what amount of harm is required.
That's right. But I have to say the First Circuit has always been much tougher on their definition of persecution. There's some really kind of horrible cases if you go back a few years and look at them. Hewitt versus the United States, a case that the podcaster himself told me to take a look at, and I have.
Well, I was told by a listener, so let's give credit where credit's due. But please continue.
This is a Justice Jackson case where the person who talked to Kevin may very well be right. This is a case that really has nothing to do with immigration. It has to do with the First Step Act, which tried to minimize the impact of stacking different penalties against the person after they had been convicted previously. And the question here was a vacated sentence, whether or not a vacated sentence could be used. And I think the interesting thing is you may be able to use, there's some very good language in Hewitt on the question of vacatur and what it means. That is, and Justice Jackson is very clear when she talks about it, the nature of vacatur. We conclude that a sentence has been imposed for purpose of the provision if and only if the sentence is extant, meaning has not been vacated. In other words, she looks at a vacated conviction on behalf of the majority of the court, by the way, and this is particularly in Section 3, A and B of the decision. And she says things like, a criminal defendant whose judgment of conviction has been vacated is to be treated going forward as, quote, though he was never convicted. And so you will see, if you go through this decision, that there's very good language that may challenge the notion of Pickering, particularly post-Loper-Bright, if we're not following Pickering and we're not following some of the sentencing cases. So
the argument is the counter argument is the definition of conviction for the First Step Act is somehow different than the definition of conviction for immigration. But of course, 101A48, right, doesn't actually really define conviction at all. So we're just, where are we getting our sources from? Where is Pickering? It's all this fluff that the BIA and the attorneys general have been saying for almost 30 years now about what they believed Congress's intent was in 1996. But if the Supreme Court's issuing strong language about what they think about a vacated conviction, that's the argument, right?
That's right. And given Loper-Bright, they certainly have an opening now if they want to do something about it.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Two other cases, Smith & Wesson brands versus Estados Unidos Mexicanos, 605 U.S., June 5th, 2025. This was a case I'd like to talk about a lot because Mexico sued Smith & Wesson and saying they're intentionally flooding Mexico with weapons. It's not legal to have a handgun in Mexico, but that the companies in the United States actually went out as manufacturers and knowingly violated the law in terms of how they marketed the guns. The court rejected the claim because it was not based upon statutory violations of retail dealers. They never really take on the notion that what Mexico is saying is not true, because it's obvious that that when we talk about the cartels and the president thumps his desk and says how, we have to go after transnational criminals, we should start with the companies that sell all the weapons to them, and they're in the U.S. And unfortunately, the Supreme Court cut off Mexico's ability to do that in that case. Mm-hmm. Another case that may have some tangential relationship to ICE and how it acts and when it shoots people, because they do shoot people, and CBP does at the border, is a case called Barnes v. Felix, 145 Supreme Court 1353. This was an effort to narrow the approach on when a policeman can use force, that is lethal force, and what was called the moment of threat rule. In other words, they would only look at the very moment before the person, the police officer, decides to shoot. The court rejected this approach, and they said to assess whether an officer acted reasonably in using, in this case, deadly force, a court must consider all the relevant circumstances, including facts and events leading up to the climatic moment. In other words, not just the moment of threat when the officer felt threatened, but everything that happened before that. There's two other cases, Estera versus U.S., which has to do with factors to be used in supervised release cases, and Phone versus Palestinian Liberation Organization, which has to do with whether or not the Fifth Amendment due process clause and the 14th Amendment's analysis are the same in determining whether or not there were minimum contacts or contacts that were necessary to bring a lawsuit against the PLO.
Could you bring the lawsuit against the PLO?
Of course, because Congress defined, in this case, Congress said the judicial predicate for the practice is whether or not the PLO paid salaries to terrorists serving in Israeli prisons, as well as to their families of deceased terrorists. In other words, just by virtue, even if they had nothing to do with the United States, but by virtue of paying families of deceased terrorists, the United States had jurisdiction. Let's talk about my favorite subject as of late, which is, as Justice Sotomayor says, the Trump administration seems to have the Supreme Court on speed dial. That was her phrase. And I think what she's talking about, of course, is the Trump doc that I call the Trump docket. They used to call it the shadow docket, but let's call it really for what it is, which is you and I don't get the benefit normally of these kinds of stays. And so the Trump docket has been an incredible change. And previously, without me giving a long speech, I put it in the context of what an author wrote about the system of justice under the Nazis during 1933 to 1938, Ernst Fraenkel, in a book called The Dual State, which, by the way, Justice Jackson mentions in one of her dissents about how it seems like we have two different systems of justice, if you want to put it that way.
Right.
And so where some explanations are given, but most explanations are not given. And let me give you the cases. In Nome versus Svetlana Doe, the district court issued an injunction against the DHS follow-up of Trump's executive order revoking parole. This is the revocation of parole for Cubans, Haitians, Nicaraguans, and Venezuelans. The district court issues a detailed 49-page order relying on the proper legal standard for an injunction. The Supreme Court stays the injunction without a word of explanation. A dissent points out that the majority botched the assessment, but it's hard to know what that assessment was since they said not a word. In Nome versus National TPS Alliance, the TPS case, the district court entered an 85-page order granting the plaintiff's claims regarding DHS efforts to vacate TPS for Venezuelans. The Court of Appeals, following the proper legal standard under Nikin, we all know that Nikin is the standard to apply whether or not a stay should be granted or not. The Court of Appeals found that a stay was not warranted. Supreme Court simply grants Trump's stay without even citing Nikin
It's
or
wild.
providing any explanation.
It's wild. And I mean, we spend so much time going through the Nikin factors, trying to make our case. What's good for the goose is good for the gander. It's very disheartening. And I'll let you continue in a sec with DVD and all the other stuff. But let me just say this, and this is the smallest of potatoes, but I clerked for a federal judge for 1 year, helped out on some big cases, nothing of this level, but like helped out on those. And it kills you to do all of that work under usually tight deadlines. And even I do not assume that there are judges with these strong political bents, forcing their entire staff to help out on these political decisions. It is really hard to make stuff up for 85 pages of fact finding. The idea that a law clerk and a federal judge could kill themselves and issue an 80-page decision only for it to get overturned by the Supreme Court without any explanation. It's just soul crushing. And maybe I'm thin skinned, and that's not the worst part about this. But oh my God, the disrespect, and we're not the first people to say this, but the disrespect for the federal court judges, the lower court judges, and Justice Jackson, who was one, has been saying things like this. It's astonishing, the nonchalance for the hard work that they do.
And I think what it does, Kevin, is it really creates a great deal of instability in the law, because it sounds like we have a Trump docket where a different law applies versus the rest of the docket where you would normally have to go through the Nikin factors, demonstrate why in this particular case the person's entitled to a stay, and have a court actually issued a response, whether it's the Supreme Court or not, but issue a response as to why a stay would be granted or not. But when you don't even know what the basis of the stay is, it really creates some kind of instability in the law, because you have no idea what the court's thinking or what guidance the court's giving to lower courts. It's just granting a stay. And this happened, of course, in DHS versus DVD. The district court issued a lengthy injunctive order barring DHS from sending a class of respondents with deportation orders to third countries without giving them notice and a meaningful opportunity to object under the Convention Against Torture. DHS then blatantly violated the court's injunction and made the, quote, factually absurd contention, this is from Justice Sotomayor's dissent, that the government, is irreparably harmed whenever it must refrain from whatever it wants to do. So the irreparable harm to the government is, we want to do this and you're not letting us do it. That's irreparable harm. And that's what Justice Sotomayor points out in Section 2A of the DVD decision. The court's majority nevertheless grants the stay of the injunction, again, without any explanation. When the district court maintains its month-old remedial order in light of the government's prior violations, so we're not even talking about prospective injunctive relief. We're now talking about what do we do about the government just blatantly violating the order. A majority bypasses the usual procedure, supports the government's challenge, and creates a new rule regarding the enforcement of an order. The dissent by Justice Sotomayor criticized his decision, finding that, quote, other litigants must follow the rules, but the administration has the Supreme Court on speed dial.
Not
And
good.
that's the decision in that. And
Not
then,
good.
yeah.
No, it's just not good. That's at the end of this, by the way, Ira, we've got a few more shadow docket cases, but just a heads up, I want to hear some positive light at the end of the tunnel after we get through the shadow docket. And I didn't mean to combine light at the end of the tunnel with the shadow, but I really like that it just came out naturally. So after we get out of the shadow, the Sauron of jurisprudence, if you will, where we're going to need some light. We need some light from the immigration guy.
Okay, well, let me give you some more darkness,
All
and
right,
then maybe
please,
we'll
please.
get there. In Trump v. Wilcox, the president fires a member of the NLRB and a member of the Merit Systems Protection Board. The members obtain an injunction in the lower court. The law has been clear for 90 years, based upon Humphrey's executor's case, that the president's firing of these people was illegal. The majority of the court, without even mentioning Humphrey's executor, grants a stay. And that's what I mean about the instability of the law. You're reading these cases. Well, what does it mean? The court doesn't say we're reversing Humphrey's executor. It is the law right now. And in fact, Judge Hull in the 11th Circuit, in determining that CAHO judges are administrative law judges and that their system isn't unconstitutional, points to Humphrey's executor and says, well, the Supreme Court hasn't said yet it's illegal. But why would they grant a stay, of a lower court injunction that cites Humphrey's executor, that says it's illegal to do this firing, but doesn't say a word about it?
They're trying to get the lower courts to do the work for them, to read between the lines so they can come in and say, we have something to resolve. The courts are confused. We need to resolve it.
That may be, although I'm not sure they need that circuit split, since they obviously don't think Humphrey's executor is good law anymore. And despite the term, and just days after the CASA decision, in the universal injunction, without any analysis whatsoever, the court stays a 55-page fact-based injunctive order that prevented the Trump administration from taking a wrecking ball to the federal government. That's Trump versus American Federal of Government Employees, 2025 Westlaw 1873449. The court's decision states that the district court's injunction was based upon the view that Executive Order 14210 and the joint memorandum of the OMP implementing the executive order were unlawful. The Supreme Court simply states, without any reference to the fact or any facts, without any determination that the facts in the 55-page order were clearly erroneous, or without even saying it is establishing a new standard of review, that Trump would likely succeed, that the EO and memorandum are legal. Justice Jackson, in dissent, noted that, quote, given the fact-based nature of the issue in this case and the many serious harms that result from allowing the president to dramatically reconfigure the federal government, it was eminently reasonable for the district court to maintain the status quo while the courts evaluate the lawfulness of the president's executive action. And they clearly just ignored all of it. So again, what's the law? Do we now have a law about clearly erroneous? Do we now have a new standard on fact-based determinations and review of those? We have no idea by reviewing any of these shadow docket, Trump docket cases. And then, even though the term ended at the end of June,
there's more.
The court's majority, ever solicitous to the Trump docket, granted yet another stay without a hint of reasoning that has the effect of eliminating the Department of Education, a cabinet-level agency established by Congress nearly a half a century ago in McMahon versus New York. In dissent, Justice Sotomayor, joined by Justice Kagan and Jackson, forcefully denounced the executive's stated purpose to shut down the department and said, quote, when the executive publicly announces its intent to break the law and then executes on that promise, it is judiciary's duty to check that lawlessness, not expedite it. So what is this really all about? I mean, and, you know, I haven't even gone into the JGG cases and what the court's doing on the Alien Enemies Act and what the courts are doing in regard to Trump's claims, like in California, what the Ninth Circuit did in regard to the use of the National Guard and the Marines. If you want to know what's really frightening, that's really frightening. Why? Because what's really happening here is the court's reluctance to look behind the reasons given by the executive for what they're doing. And that's the court's obligation. And yet, in all of these cases, where, for example, Trump says, I'm ending TPS on day one for everybody when he doesn't have the authority, and Congress gave it to the Secretary of the Department of Homeland Security. The question is, does the court have the obligation, and at this point I would say have the nerve, to look beyond what they're saying, to look beyond the authority, and actually do something about it?
Do we think a majority of the Supreme Court likes what the Trump administration is doing and so is willing to twist jurisprudence into knots to make sure it happens? Is that not a simpler answer? They're not dumb people.
No, they're very smart people. But the question is, where does this end? In other words, if Trump tomorrow says, you know, there are serious disturbances in Los Angeles and in New York and in Illinois, Chicago, requiring that I send the Marines into all of these cities. And it's clear that whatever disturbance exists can easily be handled by the local police. And then he says, and I am declaring martial rule because of these disturbances. At what point does a court say, well, this is all fabricated? I mean, this is truly the Reichstag fire, you know, where Hitler used the Reichstag fire to claim martial rule, which was the beginning of, you know, the Nazification of Germany in 1933. So this is not just about one issue about the Department of Education or not. It's about the open defiance and falsity of claims that are being made to use executive authority. It's one thing to say, I have the executive authority to do A, B, and C. I have the executive authority to cut back the Department of Education because I don't think the Department of Education is doing a good job. But if I say that, and what I do actually is to close the Department of Education, which is illegal because it was created by Congress, then the court is failing to do its job and looking behind the reasons that are offered by the executive for doing what it's doing. You know, there is a majority on the court that believes in the unitary executive. I get that and I understand that. But the question is, where does that end? Or does it ever end? But
I think it ends when the National Guard marches through Georgetown, where the justices reside.
Right. I mean, you know, what happens if they start arresting American citizens on the ground and deporting them to Guantanamo on the grounds that the president believes they're a threat to national security when there's no evidence of that? And of course, that's the JGG case. And that's the thing that's most troubling. You know, it's like the emperor's new clothes. You look at the Alien Enemies Act and you say clearly, we're not at war. There is no incursion in the United States, and there is no predatory invasion. I mean, if those words mean anything, none of them apply.
The idea that Mr. Trump is getting emergency treatment at the court for things like parole and TPS injunctions, when the real emergencies are the complete disregard and abuse of the Alien Enemies Act and birthright citizenship, things that are on their face wrong. The fact that the court doesn't treat those things as emergencies, I think, tells us all we need to know, and it's very scary.
But Kevin, what I'm saying is, even without treating them as emergencies, let's look at the Alien Enemies Act. They could have said when that case first came up, even though it may have not been briefed, they could have simply said, the Alien Enemies Act just doesn't apply here.
Yeah.
The president's use of the Alien Enemies Act is a lie. I mean, they wouldn't have said it's a lie, but they could have simply said that it didn't apply. And instead, what are they doing? They're tinkering around with accepting the notion that the Alien Enemies Act may apply, but that people have to be given notice. It's just like with the third country removal. The statute clearly has a procedure to remove people. You have the right to designate the country of your removal. That's the first provision in there. The court is playing around with all of this, saying, well, instead of just reading the statute in an intelligent way and saying clearly a person can choose to go back to their own country of birth or nationality, the court is now saying, well, before you send them to South Sudan or Libya or some place that's the equivalent of torture, you have to give them notice. And then they say, we can't send somebody back until we have assurances. So the government says we have assurances without any evidence that they have assurances that the person won't be tortured. So this is what I mean. It's a use of language where they are hiding behind what the government is saying out front, which they know, or any reasonable person would know, to be meaningless. I mean, it is meaningless that the Alien Enemies Act could be invoked in this situation. There's not a shred of evidence that we're at war. There's not a shred of evidence. In fact, the evidence is to the contrary. Remember, all the intelligence reports came out and said Trump's claim about Tren de Agua being controlled by Maduro in Venezuela just simply wasn't true. So we know that they're making false statements. They're using those false statements as kind of cover because it's, mimicking the language, but in fact doesn't exist. And if you go down that road, and this court seems to be willing to go down that road, there is no end. Because at some point, Trump is going to say, I am putting troops in every city in America because I need to have martial rule. We've had people rioting in New York. We've had people rioting in Illinois. And therefore, I believe we should have martial rule in the United States.
This has been a terrifying conversation. I knew it's hard to argue. First of all, most of what you just did was case law. It's hard to argue, of course, with any of it. This is a scary time. You and I talk about this kind of stuff all the time because, of course, you're a mentor to me in addition to a podcast host, and in addition to a podcast guest, and in addition to being very new to immigration as you are. But I got to end with some light, if not for the people listening, for myself. And you and I have talked about this. I've talked about it with my father. Things seem very dark right now. But also, if you go back to the time where you were growing up, when you were coming of age in the 60s, as an adult, things were much darker. There's de jure discrimination. There are lynchings. That's a bit earlier, but still, there's lots of violence. Gay people didn't exist in public. There's war in Vietnam. There's death. The Civil Rights Act is barely existent, of course, not until 1965. And so right now is the reaction, but by definition, the reaction isn't as bad as the pre-action. So to me, it gives me comfort to think that things have been worse, and we grew up in a more progressive life, I did, than did my parents and their parents. But am I wrong? And if I'm not wrong, how do we get back to it? How do we get back to taking the country and the narrative and the momentum for progressive ideals and fairness and humanity? It's a big question.
Yeah, I mean, it is a big question. I think we do it lots of different ways, but I am a very strong believer based on what I witnessed, particularly even with Haitians in the immigration context in the late 1970s and early 80s in Miami. You need to confront mass deportations by having mass demonstrations. And I strongly believe that. I believe people need to be out in the street, that, even though the younger culture is a culture of, looking at your phones and everything else. But until Americans see large numbers of people out on the streets protesting peacefully, protesting these kinds of issues, I don't think we're going to make much progress. And the turning points, of course, in Miami, for example, even with the Haitians, when Haitians started to demonstrate, it wasn't only the legal cases, and the legal cases were a component of it, but it was a mass movement where people came out, and the effect was to show to the American people that Haitians were human beings, that they were your neighbors, that they were people who had real struggles, and that they were people who were truly afraid of being deported back to their country. Trump has taken away legal status for 1.7 million people. We're not talking about criminals here. We're not talking about what he calls the worst of the worst. We're talking about people who have temporary protected status and people who were paroled into the United States. All these people had checks before they came in. There's always some exception of somebody who gets through, but we're talking about a population of 1.7 million people who had fingerprint checks, were cleared before they entered the United States, or were cleared while they were here. And those people are going to lose their status now. 1.7 million, because Trump wants to prove that he can deport millions of people, even though he's taking legal people and making them illegal. Those people should be out on the street. If you had 10% of those people out on the street, you'd have 170,000 people, right?
By the way, you add the DACAs in a year or two, you're at 2.7 million.
Right. So the answer is, I know people are afraid. I know this is a dark time, but unless you stand up and stand up for yourself, there's no one else who's going to be there to do it. And, the whole strategy of the Trump machine and the Miller machine is designed to create fear in people, mistrust of one another. They're even going after citizens by getting them basically to say, we're going to denaturalize you, as a way of trying to shut them up when their family member is taken away. So the answer is, people have to stand up, assert their rights. They have the right to be heard in the United States. And I can tell you that their overreaching has already resulted in the American people understanding that what they're doing is indecent and indefensible. You've seen the numbers. The percentages of people no longer support Trump's policy. It's one thing to talk about the border. It's one thing to stop the border. The border was stopped in July of 2024 when Biden was still there, even though Trump's taking credit for it. It was actually closed in July of 2024. But that's one thing. And the American people were responding to this kind of idea that we were being overrun. People understand now that that isn't the case. People understand full well what's going on when a guy in a mask, unidentified as an ICE agent, comes and throws you in a van. That's not America. That may be Russia. It may be China, but it's not the United States of America. And Americans understand that now. When they see their friends, their neighbors, their caregivers, those are the people just being picked up and arrested. So my hope is, the bright side is, that the more aggressive and nasty they get, the more the American people understand that this is not a project to keep people safe. It's to make America just a solely white country again, because that's Trump and his anti-immigrant vision of America. And I believe that if people get out and they demonstrate and we continue to file these lawsuits, that we're going to have a change even during the Trump administration.
To put a pin on it, Americans need to come out and protest and realize that Project 2025 is Project 1933.
Right.
Oh, we can still joke. We can still podcast. Thank you, Ira.
All right. Well, thank you. This has been a pleasure as always. It's great to talk with you.
It's a pleasure to have you on. I hope everybody enjoyed it. Bye, Ira.
Take care.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.